Welcome everybody. Thanks for joining us at our HR Club. Today we are going to be running a redundancy masterclass for you. So just to do some quick introductions, my name is Caitlin Anniss and I'm an HR consultant with Narrow Quay HR. And I'm going to be presenting the session today along with my colleague Sarah Martin, who's also an HR consultant at Narrow Quay. Sarah is going to be dealing with the questions as people ask them and chairing the Q&A at the end. And also Gareth Edwards, who's a partner at VWV and heads up the employment team. So before we look at what we're going to be covering today and how we're going to run the session, I just wanted to mention that the next HR Club is going to take place on the 18th of March and is going to be looking at sexual harassment in the workplace. So details will come out about that one in the new year. And also to let you know that Narrow Quay are going to be running a session in the spring next year on the Equality Act and unconscious bias and how that can impact in the workplace. So again, details will come out of that about that in the new year and will also be on our social media channels. So the session today is going to be Gareth and I talking to you about some of the issues which crop up when handling a redundancy. So Gareth is going to cover the legal aspects and I'm going to look at the more practical aspects. And as I said, Sarah is going to deal with any questions. Please feel free to ask us questions as we go along using the Q&A box. And Sarah will prompt us to answer them if we can as we go along, and then also be an opportunity to ask questions at the end. Emma, could you move me on to the next slide, please? So this is just an agenda for what we're going to look at today. So what we hope to do is take you through the various stages that you would need to consider if you are contemplating or going through a redundancy process in your workplace. So looking at the initial steps, thinking about the consultation process, which will vary, of course, depending on the number of staff involved, thinking about how you select staff and whether or not you would ask for volunteers, looking at the sort of final steps of the process in terms of notifying people of redundancies and payments, and finally looking at some of the tricky areas that can crop up as we go through the process. Could we move on to the next slide, please? So I'm going to hand over to Gareth now to talk about the initial steps.
Thanks, Caitlin, and good morning, everybody. So just a little bit of law to start us off in terms of a redundancy situation, because it's got quite a precise definition if you're then having to deal with issues that are when redundancies are challenged and whether there's a redundancy situation or how it's then being dealt with. So to start with then, when you're doing your business case planning and you're looking at change in the workplace, obviously it may well be that you're talking about redundancies. And in law, a redundancy is where there is a reduction or cessation of a requirement for employees to do the work that they're currently doing for you, so work of a particular kind. And this normally boils down to if, for example, there's a business closure, or if there is a closure of a workplace or a department, or there is a reduction in requirements of the business that employee does. That could be because there's been a change in the business. We've all gone through very challenging times over the last 9 months, or it could be because of technology or changes in work habits that you actually just don't need as many people doing those jobs because you've been able to introduce efficiencies or streamline how things are being done. So essentially, there needs to be this reduction or cessation in the requirements for people to do the work that they were previously employed to do. Technically, if you're defending an unfair dismissal, which will come to near the end of the process, then if you're putting redundancy forward, you need to ensure that your facts and circumstances fall within that definition. If they don't, you may still be able to argue some other substantial reason. So you may well be calling it a redundancy, but it may well be that it's a business reorganization that is a sufficiently substantial reason to justify dismissal. So quite often those get looked at in the round together with regard to reorganization and redundancy. Sometimes you're doing a reduction because you're outsourcing, and if it may well be that that is a redundancy if you're going to also change the way in which you're doing things following the outsourcing and asking a third party to help with, I don't know, payroll or particular aspects of what's being done. The outsourcing could also obviously trigger TUPE, the Transfer of Undertakings Regulations, and in those circumstances, it wouldn't be a redundancy necessarily that you're dealing with, it would be a TUPE consultation that leads to the transfer of the employees to the third-party provider, when they may well then have some organisational issues and redundancy at that point. So just be, as I say, part of the business planning is to really understand the framework in which you're working. If you think you're dealing with redundancies, then the other thing just to have in your mind as part of the framework, which we'll probably come back to a couple of times, is ultimately looking at the leading case law on redundancy as to what is a redundancy situation. And that's the case of Safeway Stores and Burrell. It's quite an old case now, it's from 1997, but it established essentially the three-stage test to decide whether there was a redundancy dismissal. And the first of those is that there needs to be a dismissal, so you've actually given someone notice to terminate their employment. Secondly, that you've got the requirements of the business for the employees to carry out the work that they were doing has either ceased or diminished. And thirdly, and this is the area where there's always the dispute, were those circumstances the cause, either wholly or mainly, of the reasons for the dismissal. So this is where a redundancy situation may be challenged on the basis that someone feels that it's artificial or there are other reasons why they've been asked to go. But essentially, redundancy dismissal requires the circumstances around the reduction to then lead to the actual dismissal. And there's obviously quite a lot of case law about whether mobility clauses, for example, allow you to move somebody rather than have a redundancy. There's always a question about bumping when you start looking at redundancies, and we'll come back to bumping a little bit later. And obviously there's quite often people may raise grievances or otherwise challenge the reasons for the redundancy or why they're selected within the process, and we'll come back to some of that as well. So there can be quite a lot that may be challenged. So being very clear at the beginning as to what you're doing and why you're doing it will be very helpful in then having some consistency of approach in terms of looking at your business reasons and how they fit with the law. So that's the sort of legal framework, and I think Caitlin's going to talk to you a little bit about how you might then start to plan to pull together a redundancy proposal.
Oh, sorry, Emma, could we go back to that previous slide, please? Thank you. So I'm just going to pick up a little bit, following up on from what Gareth has talked about in terms of what does this mean then in terms of your planning at the very early stages of a redundancy process. And that there does need to be that planning stage at the initial stage, because as with many other processes in the workplace, it can be easy to rush that stage in a desire to start the process quickly, but getting that stage wrong can lead to real problems and could even threaten the fairness of the process. One of the decisions that needs to be made is who is going to deal with the various stages of the process. So who is going to be involved in consulting with staff, who's going to score staff against selection criteria if you're using those, who's going to make the decisions on the redundancies, and who's going to be kept back to hear any appeals. It's really important to give careful thought to who is going to carry out each of those roles, and particularly important to have some people who've not been involved in the decision making who can then deal with any appeals. And that of course can be really challenging if you're in a small organisation, because it's often very difficult to find that range of people who have not had the involvement in the process. So thinking that through early on can be really helpful. And it's also really important to think about communications at this stage. So once you have your business reasons thought through, which will flow from the sorts of issues that Gareth has talked about, then that needs to be included in all your communications with staff, with the aim of getting people to understand where you're coming from and what the reasons are behind the need to make these redundancies. So that message needs to be as consistent as possible throughout the redundancy communications and throughout the consultation process. Can we move on to the next slide, please, Emma, and I'll hand back to Gareth.
Thanks, Caitlin. So what next point when you're doing your planning is to obviously look at the potential numbers that are affected by this. And we'll talk a little bit about the triggers for collective consultation in a moment. But as part of looking at the workforce that's impacted by this, you'll be thinking about how you're going to manage the pools for selection and about who it is who's potentially at risk of redundancy. And when you're looking at a redundancy pool, essentially, in terms of the legal framework, you're looking to demonstrate that you have acted fairly in terms of the pooling that you've undertaken. So if you're in one of those situations where you potentially need to reduce costs, for example, then you might well have quite a wide pool in terms of looking at where the areas where you can reduce costs in order to make the organization more efficient or reduce the cost base of the organization. Or you might decide to particularly target particular areas of your business where you think savings can be achieved without too much impact on the wider business. So it is for you as employer to decide the basis upon which you want to pool. But once you've started to make your decisions around pooling, you do then need to be mindful that ultimately that could be challenged, and you need to be able to show there's a level of fairness and objectivity in terms of what you have done. If you're a unionized environment, obviously it may well be that pooling decisions and selection decisions have to be made in conjunction with the unions and taking into account any collective agreements or guidance that's in place. So be mindful of the wider context. Also, you may have information in consultation groups or other agreed mechanisms as to how you're going to go about that. So you need to think about that and any redundancy policies that you have as to how you'd look at these issues if they have been predetermined. Otherwise, as I say, it's in the employer's discretion and there are no fixed rules. But ultimately, the case law stresses that part of looking at whether redundancy was a reasonable response and therefore a fair dismissal if you're challenged later, that the pooling range is one of those areas that can be examined, and you have to show that you have it is your decision, and ultimately people may not ultimately agree with it, but if providing you can show that you've genuinely applied your mind to it and addressed the issue fairly, then essentially it is your decision as the employer as to how you go about your pools in terms of deciding who potentially will be placed at risk. Quite often there's an issue with regard to when you start to talk to the workforce about redundancies, that obviously that impacts on morale, it can unsettle people and it can reduce productivity. So employers naturally want to keep pools as small as possible. And if you have narrow pools, then you just have to work a little bit harder to show that you have genuinely thought it through as to why it is that you've got a smaller impact in particular targeted areas. It can be done, but it's again would be one of the areas that can be challenged. And sometimes, whilst it's not unlawful to have a pool of one, it can be quite hard at times to be able to justify that if someone doesn't have a unique role in the organisation or start to draw comparators and therefore try and widen the pool for selection. So I think at this stage, just say that obviously because we'll come on to selection criteria and how you pull the various parts to get those pieces together. But when you're doing your planning, think about who's potentially impacted and then think about what pools you may have in terms of the savings that you need to make. I've mentioned collective consultation in terms of thinking about numbers, and that's just, if we move on to the next slide, please. The next part of your planning, because this affects the potential for timescales, is to think through how many people you are potentially proposing to dismiss. So when you're talking about collective consultation, if you propose to dismiss 20 or more employees in a 90-day period, then you have triggered the collective consultation rules, and you have to consult with elected employee representatives before you can then effect your redundancy dismissals. In terms of thinking that through, the test about whether you've got identified 20 or more that you're proposing to dismiss, they are at what's known as one establishment. So if you are a multi-site organisation, you need to think carefully about whether each site is its own establishment for the purposes of these rules, and in those circumstances whether you can manage the collective consultation obligation by dividing up the numbers across the sites and maybe staying below 20, which you're entitled to do. You wouldn't be criticised if you were to manage things in a way that allows you to manage it with less than 20, provided you could show that that is a genuine thing. Bear in mind as part of this that if you're also looking at changing terms and conditions, then if you are going to go through a process where you would enforce that change by giving notice and engaging on new contracts, rather than necessarily getting agreements if that's not forthcoming, then those also count as dismissals for the purposes of whether you propose to dismiss 20 or more people. Again, part of the planning is to really think through the impact and also the timing of these redundancies. Once you've decided you've got collective consultation, if you've got 20 or more, those employees and that reason essentially is ring fenced. So you could start a process where you're talking about 20 or more. You potentially could add a few more later if you needed to, and that wouldn't make you have to restart the clock. It may well be that you've done your first wave and then a month later you need to start again. If you've got less than 20 second time round, that wouldn't upset what you've already done first time round. And potentially, if you needed to do a second wave where there was more than 20, you could restart your collective consultation. Obviously, there are wider employee relations issues that you need to bear in mind if you're doing that. The opposite also applies. So if you start with 10 and then you add another 10 over a period of a month, you will then have triggered the 20 or more in a 90-day period, and you will then have to start collective consultation with all of them. So it's worthwhile thinking at the start rather than allowing the to snowball a little in terms of how you do that. If you've got 20 or more, then you've got 30 days consultation. If you've got 100 or more, then it's 45 days consultation. So it's a slightly longer period if you've got a larger reorganizational redundancy process. I talked about ultimately needing to consult with employee reps, and Ken is just going to talk a little bit more about the process about how you put collective consultation in place.
Thanks, Gareth. So yes, we can see here that if there is an obligation on you as an employer in a collective consultation situation to consult with appropriate representatives of affected employees. And so the first step will be to identify who are those affected employees and then their representatives. And remember that affected employees can be not just those people who are going to be dismissed, but also people who may be affected by measures associated with the redundancy. So that might be changes in line management, changes in structure. So you need to give a little bit of thought to that slightly broader group who may be affected. So who do you need to consult with? Who are these representatives? And you've got three options. It could be that you need to consult with a trade union, as Gareth has mentioned. You may have a standing body of representatives already in place who you could use for the purpose of consultation on this redundancy process. Or you may need to elect reps purely for consulting on this redundancy process. So if you have no recognised trade union, then you can decide which of the other two options to take. And employers will generally opt to elect representatives purely for the process of, for the purpose of this particular redundancy exercise. There are statutory rules in place covering how you need to run that election to ensure really that there is a fair process taking place. But there is some flexibility in terms of how you decide to run that election. For example, how many reps you want to have in place, from which areas of the business, and over what timescale. So in practice, what does that look like? Well, you need to give some thought to how many representatives you think you need to represent the staff who are affected. Do they need to cover different areas of the business? So do you need to specify whether you need reps from certain areas? And you need to think about timescales for this process. So often the time for the election of those reps and perhaps some training isn't adequately allowed for at the start of the process, and that can cause some pressure at the beginning of this process. Think about how you're going to communicate this with staff. How are you going to tell them that you need to elect reps? Think about what will work best for your business. This may be complicated at the moment by the fact that you may have some staff working from home, perhaps some staff furloughed, and other staff within your workplace. So you may need to think about a variety of methods. We've worked with clients over the summer where almost all staff were either furloughed or working from home, and the election of reps was done electronically, but it did take a bit of time to set up, and so you do need to factor that into your timetabling. Sometimes, of course, you may not actually need to hold elections if you get the right number of people coming forward for the roles, and so you may not actually have to take that step. But if an election is necessary, then that does take a little bit of time and again needs to be planned and thought through. And then finally, when you do have your reps in place, think about whether they need any training. They may well have never done this before. They may not understand what their role is, what's expected of them. And so providing them with some training at the start of the process can be really helpful to get the most out of that consultation process. Could we move on to the next slide, please, Emma? And I'm going to hand back to you, Gareth.
Before we move on to the next one, Gareth, we've had a question come in, which I think is probably one for you. If you have a 2-year fixed term contract coming to an end, does that constitute a redundancy situation, and should you go through a redundancy consultation process?
Potentially, I think, is the answer. It may well depend upon the nature of the fixed term contract and the basis upon which you've put the contract in place. The expiry of a fixed term contract is a dismissal, and it does give potentially the individual an unfair dismissal right. So if that person was on a fixed term contract because there was a particular stream of funding or there was a particular project to do, then yes, you need to consult with that person about whether that project is over, the process to come to an end, and you'd then look at not extending their fixed term contract or not renewing it. So you'd want a process around it, whether you formally call it redundancy at that stage or not. If it is the work's continuing but you don't want that person to do it, then it may well be more complicated in terms of the reasons why you're not going to renew or extend the fixed term contract. But in principle, it's triggering a dismissal. So yes, you need a process about it, and it may be relevant to a redundancy if you're managing that.
Another question we often get asked, Gareth, is around those employees that have got less than 2 years service, and whether from a risk perspective you should treat them differently to employees who have lengthier service.
In a redundancy situation?
In a redundancy situation.
I think if you're formally announcing redundancies, then you would deal with all of your staff together. If you're thinking you can potentially manage things by reducing headcounts around the edges, then it may well be, because someone with less than 2 years service doesn't have an unfair dismissal claim, that sometimes it's easier to talk to some of those people or to let people go who haven't been with the organisation very long. The risk you run is one of, if they assert discrimination and they've been treated less favourably because of a protected characteristic, either something they've already raised in their workplace or whether potentially age, etc., in terms of challenging those types of decisions. So it's probably best to include them in the overall process, but sometimes if an employer needs to act quickly in terms of its cost base around its salaries, then there are ways of looking at your short service employees in relation to a review of whether you retain them or whether you let some of them go. Okay, so we move on to individual consultation. So as well as following the collective consultation, if you need to, if that's been triggered, and going to a number of bits of statutory information around the reasons for redundancy, if you've done that, you still need to follow individual consultation. And if you haven't done that because you've got less than 20, obviously you need to be talking to each individual in any event about the redundancies. Ultimately, as well as the redundancy situation that we talked about, the Safeway case at the beginning, the other half of the test of an unfair dismissal and defending a case later if you're challenged is to show that you followed a fair process to establish that redundancy was a fair reason for dismissal. There is no statutory requirements around a fair process, so potentially it's partly led by the facts, but there's some quite established case law which will look at what it is that you should do in relation to following a fair redundancy consultation process. And there's obviously ACAS guidance and other guidance as well, which you should be mindful of and be thinking through as to how that applies in relation to the process. And I think Caitlin is going to talk you through what the actual process should cover and the main areas that you should make sure you've covered off.
Thanks, Gareth. So before I talk through what a process might look like, it can be quite helpful to think about what do we actually mean by consultation, and perhaps to start by what consultation is not. So consultation is not information flowing in one direction only. Equally, it's not a negotiation which requires agreement. So what it is a two-way process, and what we're looking for is a genuine consultation, inviting feedback and demonstrating that some thought has been given to issues that are raised by the staff. So as Gareth has said, there's no statutory guidance on exactly what a timetable for a consultation process for less than 20 staff should look like. But the process must be fair if we want to avoid challenges, and therefore there does need to be sufficient time to carry out a meaningful consultation, and there's lots of guidance in case law about what that might look like. When you're thinking about your timetable, factor in the notice periods that you are going to have to give staff who are made redundant. So think about perhaps the end of the process and think about working backwards. Setting out a timetable is really important, and you can do that at the start of a process with suggested dates, but you do need to factor in some flexibility. So give yourself enough room to amend those dates if necessary, because very often things come along which means that the dates have to be pushed back. You can share that draft timetable with your staff or with your reps if you're in a collective situation early on in the process, and then of course you can talk to them about changing things if needs be. So if you're thinking about a consultation process where there's less than 20 staff, how many meetings are we talking about? What might they look like? It's likely to involve at least 2 collective consultation meetings. You may need more depending on the issues that come up and whether you need to follow up with staff. You will then need to move into meeting with staff individually. With those staff who've been provisionally selected for redundancy, you're certainly going to need to meet with those staff once. You may need to meet with them twice, depending on the issues that they raise and whether you need to go back to them. And finally, you're going to need to allow time for any appeals once redundancy decisions have been confirmed. So the first meeting that's going to be held with all affected staff should cover the following points. You want to talk about the reasons for the potential redundancies, and we talked about that early on, and having this very consistent message that flows from your business reasons and your thinking at the start of the process. You want to talk about how many jobs are at risk, and being very clear that redundancies are they aren't decided at this stage, you are in the consultation process. You want to talk about ways of avoiding redundancies, and you will have given some thought to what those options might be. So could you be looking at restrictions on recruitment, alternative employment, and we'll come back to that later, retraining, perhaps voluntary early retirement and voluntary redundancy, and again we'll talk about that in a moment. You can ask the employees for ways to avoid redundancies, because they may have some ideas around changing working patterns, for example. Perhaps people going part-time may give you some possibilities of avoiding some of the redundancies. And you would also want to talk about the pools and the proposed selection criteria if you are using them. You need to take careful notes of those meetings because you want to demonstrate that you have listened carefully and then go back to people after those meetings. What we would generally suggest and what we will do if we're supporting clients with consultation meetings is to prepare a Q&A document which then gets circulated afterwards and can move through the consultation as things get added in. That can be really helpful. Between the consultation meetings, you need to consider the points carefully that have been raised by the staff or by the reps, and consider how to respond and whether the process needs to be amended in any way or whether you can change your decision making as a result of that. And then when you move into individual redundancy consultation meetings, those really are an opportunity for those employees to challenge the fairness of their selection for redundancy, to put forward suggestions again of ways that those redundancies might be avoided, to talk about any alternative employment options, to talk about any concerns that they might have, and if you've got to the point where that redundancy is being confirmed, to talk about their entitlements. So what are they going to get paid if they are made redundant? What will it look like for them in terms of notice? Are they going to be required to work it? Will they be paid in lieu? All of those practical things which are really important to staff at that stage of the process. Remember that staff have the right to be accompanied by a trade union rep or a colleague in those individual consultation meetings. So when you get to that stage, you do need to offer the right to be accompanied. And I've mentioned alternative employment. We will come on to this later, but you do need to be thinking about whether there are any alternative employment options for staff and feed those into your consultation process, because they may offer some opportunities to avoid some of the redundancies. Can we go on to the next slide, please, Emma, and I'll hand back to Gareth.
Caitlin, can I just ask a question about timings between meetings? If it's not a collective consultation redundancy process, and an employer wants to move through the process as quickly as they can, broadly speaking, what is the sort of total time scale involved, and what's the minimum time you should leave between meetings?
So it's always going to depend on the facts for each individual employer, and as we've said, there's no statutory guidance on those smaller scale redundancies, but I think what you want to have in your mind absolutely is ensuring that that process is fair. And so what we wouldn't want to see is a process that is rushed through and that leaves employees feeling that it's not a genuine consultation process. So I think you couldn't, for example, have consultation meeting 1 on one day and consultation meeting 2 on the next day, because that doesn't demonstrate that any time is being given to the issues that are being raised. I'm sure we will all have seen some redundancy processes involving very few redundancies that are done over a relatively short period of time. But I think you just need to be sure that you're not rushing it, and really you would want a few days, ideally a week, I think, between those consultation meetings.
We've also had another question come in. Do you have to advise all employees, of which there are 80, of the intention to make redundancies if you're only looking at one department involving just 3 people in the business?
Shall I go first to the legal bit, and then there might be some wider HR issues to think about. The legal answer is no, you wouldn't need to tell the firm about it or the organisation. You could just talk to those 3 individuals about if they're all in the same pool, and that's right. If you're looking at a department as the pool and you think you need to ultimately let 3 people go as redundant, then you'd start with talking to the department about it. You may want to flag on a wider basis that there are restructures or redundancy discussions within the organisation. Obviously, you want to be careful of morale more widely and not unnecessarily unsettling people. But you wouldn't need to tell everybody unless that's how you operate as an organisation. You think it'd be fair to tell people so they understand. It's a relatively small organisation, the impact on some people. But there's no legal obligation to do so.
Nothing to add to that.
Thanks, Caitlin. So I think, therefore, should we move on to volunteers and whether you should seek volunteers? This is entirely in an employer's discretion. Sometimes if a larger organisation potentially is looking to achieve cost savings, it may have a rolling programme of voluntary redundancies, and it may well have no criteria, no set expectation as the number of people who are going to apply, but it will just run a voluntary redundancy scheme over a period of time. If that happens, you could say that there are no proposals to dismiss anyone as redundant, and therefore the 90-day consultation, the consultation period rules are not, collective consultation rules are not necessarily engaged. If you are looking at volunteers as part of the first wave of a number of redundancies that you need to make, then potentially the consultation rules are engaged. So you need to think about, if you're going to look at the volunteers, the basis upon which you're doing it. Is it part of a targeted approach, and is it a part of implementing a process and letting some people volunteer as well as having to select some, or is it a wider cost-saving measure which you've just got a voluntary redundancy program running in the background? If you do decide to ask for volunteers, they will count towards your overall numbers. Someone who is volunteering is not essentially resigning. The case law has established that they're volunteering to be dismissed on the grounds of redundancy. So they are a dismissal for the purposes of how you might manage your numbers. So seeking volunteers is not a way of extending whether you've got 20 or more in terms of those that you're proposing to dismiss. The volunteer numbers would count towards that. Sometimes you might look at early retirement as well. And if you're doing that, you just need to be careful about how that's positioned and any age discrimination concerns as to how that is put in place. Caitlin, do you want to add to that?
Yes, I think just some practical things to think about would be being clear if you do decide to look for volunteers as part of your process, that you may want to show people that you may say no to some people who come forward to volunteer for redundancy, because some people may come forward who you really want to keep, and so you would not want to have to agree to that. And you also may have too many people come forward, so you may want to think about how you communicate around that. And otherwise, just think about the process that you are asking people to follow. So be very clear about how you want them to come forward. Do you want to set a date by which you want them to come forward, which will help you then manage the process as you go through it.
If you are offering voluntary redundancy, do you have to offer an enhanced package?
I suppose if you're doing volunteers as the first wave of redundancies and you want some take up because it will be less of an impact on managing the organisation later, then you might want to offer some early incentive for people to volunteer. You don't have to, depending upon whether you offer statutory terms or enhanced terms already. So I think it really comes down to the reasons for seeking volunteers and the extent to which you want to encourage volunteers, depending upon the speed at which you need to act and the processes that you want to follow. That will probably largely determine whether you want to have volunteers in the first place, and then thinking through whether you want to incentivize those volunteers to basically come forward early to help with the redundancy and the cost reductions you're trying to achieve.
Thank you.
Could we move on to the next slide, please, Emma?
So this is dealing with selection criteria, and as well as having your pool for selection. Once you have your pool and you've told people that they're at risk and you are looking to work through the redundancy, you then need to think through the selection criteria that you're going to apply to that pool. And again, in terms of the legal position, the only requirement is to show that you've acted fairly, and ultimately you could show that it's, the decisions were made were reasonable in terms of an overall fair dismissal. And the wider guidance from case law and from ACAS is to think about essentially that your criteria, so far as possible, are objective and they're capable of some form of independent verification. So can they be measurable in terms of what you're looking to score, and try and avoid them being based on just purely subjective views or personal opinions. So you might want to look at performance and ability in terms of someone's capability of doing the job, and you may well want to tailor the criteria to particular aspects or key parts of a job description. If you've got a pool of, I don't know, 10 engineers and you want to retain 8 going forward, you need to lose 2. Can you look at the key things that they do and then look at how you might score performance and ability? Sometimes on a wider reduction basis, you might look at basic metrics around attendance or disciplinary records. Obviously, there are potential things you need to discount in relation to attendance in terms of potential disability challenges or other wider sickness or maternity related. But again, it can be a useful starting point. And you probably want about 4 or 5 selection criteria that help you ultimately think about the fact that you're trying to retain the best people for the job going forward. So you need to want to be able to show that you have applied selection criteria that allows you to really focus on those that you want to retain. You can potentially use subjective criteria in certain circumstances, but think about whether they can be applied objectively. And certainly in some of the work that I've done with clients, we've looked at whether you have more than one scorer. So whether, if you are going to apply some people's views, certainly, for example, in various sort of professional roles, where it is about how it's very much a view as to how somebody does their job, and as well as the metrics about how much they can earn the company. It's then also how are they a team player, or how do they engage, etc. It may well be you want 2 people to do the scoring independently of each other, and then do a moderation exercise with the help of the HR team to resolve that. So ultimately, think about how you would explain the criteria both to the individual and, if challenged, more widely. Caitlin, do you want to add to the challenges of selection criteria?
Yeah, I think just to add, one thing that can be quite helpful is potentially to give some guidance or some training to the people and the managers who are going to be scoring staff, because it can be quite complicated and they may never have done that before. So thinking about giving them some guidance or giving them some training can be really helpful. I think the other problem area that often comes up is that when you get to individual consultation meetings, the members of staff who've been provisionally selected for redundancy understandably want to talk about their scores, why they've been scored in a particular way, because that's what's led to them being selected. And that's absolutely fine, and that's part of the meeting, and that's something that you should be ready to discuss with them. What they may then want is to find out how other people in the pool were scored, and that's more problematic. So what you wouldn't want to do is simply share all the scores for all the team members with everybody. And we would recommend that you resist sharing scores, and if you really feel that you need to take some guidance, and absolutely to do it on an anonymous basis. You wouldn't want to be revealing who has been scored with what, but it's complicated, and it would be better to avoid. If you think that comes up as a challenge, it would be good to seek some guidance.
I agree, and potentially sometimes the way of doing it is to tell the individual obviously their scores, but then also tell them the average score. So added up everyone else's scores and divided by the number in the group. So you've got an average. So they've got something to compare against, and they can see then maybe how finely tuned the decisions are. And obviously you can then hear representations about whether they think their own scores are fair in that context, which will then help you manage the overall fairness challenge later.
We've had one question. It's about service and selection criteria, and the question is, in this case, can a company overlook the short service over long service employee? So I think this is referring to the sort of last in first out idea, or possibly if you've got somebody with longer service but you want to keep the person with shorter service, is that okay?
And ultimately, yes, you can. Obviously, if you're looking at last in, first out, people worry about whether that can be challenged on age discrimination or other grounds these days. But it potentially is still a useful tiebreaker, or to ultimately, if you can't otherwise make a differentiator, maybe retain the longer service people with the greater experience. But I wouldn't have that as a working assumption from the start. You need to have scored people. And generally, yes, I think you can apply criteria where essentially you're looking to retain the best people for the job. So if someone has relatively short service, but they clearly have a strong aptitude for something and they score well, whereas someone who's been doing it a long time may not be doing it as effectively, whilst obviously that's a difficult conversation to have with the long-serving individual, it would still be potentially fair criteria to have applied. So I don't think you just have to look at whether junior staff should go first, and in fact, it might cause you some problems. Okay, so I think if we move on to the next area, which is once you've gone through your selection process against your pools and you're looking at the consultation process, you might then look to think about how you confirm the redundancies. So far you've been talking to the employees about being potentially at risk of redundancy, telling them there's an impact on their role, and looking at the various alternatives and also reasons for their redundancy. As you bring that to a close, you'll be looking to then confirm the redundancy, and you need to formally confirm, we would suggest in a final consultation meeting, but also then in writing, because it may well be the employee doesn't hear everything that's been said or is not clear in writing with regard to giving notice of termination and actually dismissing that employee on the grounds of redundancy. You need to obviously make sure that when you give notice, you are taking into account the contractual notice arrangements and whether there is statutory notice, which is 1 week for each area of service, or whether there is a contractual overlay of that in terms of the notice period, and whether you want, as Caitlin flagged earlier, whether you want people to work their notice because there's still a handover or there's still tasks to be completed, or whether it is something where you would be comfortable paying in lieu of notice and agreeing that person can go essentially without working notice and they'll receive a payment in lieu to satisfy your contractual obligations on notice. And Caitlin mentioned earlier the offering of the right of appeal. Quite often it is best practice to offer a right of appeal. It may well be in a redundancy situation that you don't specifically have to, and the case law shows that ultimately, in terms of your, if you're comfortable that there has been a proper and fair consultation, as Caitlin outlined earlier, and all issues have been addressed, then it may well be that you can have a fair dismissal without offering a formal right of appeal, because you want some certainty at that particular point that you're giving notice. If you've got concerns, or if it's your normal practice to, or it's in a policy, then of course offer an appeal. But bear in mind, obviously, you're then thinking of that the uncertainty continues for a little bit longer as to the impact on colleagues if someone is appealing, and potentially if they're successful in that appeal. As part of giving notice, you'll then want to also, let's moving on to the next slide, confirm the redundancy payments that they're going to receive. And there are two aspects to this. There is a statutory redundancy entitlement, and there is also a potentially a contractual entitlement if you have enhanced redundancy terms. To receive a statutory redundancy payment, you need to have 2 years service as an employee, and you need to have been dismissed on the grounds of redundancy, and you need to be an employee in the first place. So sometimes some of the workers or slightly more flexible arrangements may raise a question as to whether there's an entitlement to redundancy payments if the engagement's coming to an end. I'm sure everyone will be familiar with the calculation of statutory redundancy pay. It takes into account someone's age and length of service, and there are various bands with regards to whether someone is under the age of 22, between 22 and 40, and then 41 and above. And there's also a cap on a week's pay if you're operating the statutory scheme, which is set on a statutory basis, and the week's pay is reviewed annually on the 6th of April in accordance with the Retail Prices Index, and it's currently set at £538 as a maximum, or it's someone's actual pay if it is less than that. In terms of contractual schemes, it may well be that you've got an enhanced scheme where you agree to enhance redundancy payments. So it may well be that you look to basically enhance that. If you are enhancing, then bear in mind that some people may challenge that again on a discrimination ground. So the way to try and deal with that is to follow the statutory scheme with regard to the 3 bands. With regard to, you can then flex the amount that's payable for each year of service. But if you want to recognise long service, then you need to follow the statutory scheme, because there's a specific exemption from any age discrimination challenges if you follow that particular scheme. Okay, shall we move on to some other, we've highlighted a few, but some tricky areas that may well come along as we go. So we go to the next slide. Caitlin, do you want to kick off?
So I'm going to talk a little bit about how we may need in the current situation to consult with staff who are either working remotely or perhaps furloughed. So it's a bit more complex than perhaps it previously would have been in terms of consultations with staff. So how do we do it? So it's absolutely possible to do this, but you need to give it a bit of thought at the outset. So consultation meetings can take place via video platforms such as Zoom, but you need to make sure, of course, that staff have the IT equipment available to be able to access that and take into account any reasonable adjustments that might be needed for any staff who are disabled in order to allow them to participate. So you do need to plan the process out, and you need to give the staff involved enough information prior to those meetings to ensure that they understand what is happening. And you may also want to build in a bit of extra time into your timetable to allow for any technical problems which arise from a new way of working. Large staff meetings held remotely on something like Zoom are potentially more problematic. So there may be some limitations to meeting with a big group of staff online, and you may decide that it's not appropriate, for example, to use a large Zoom call as an appropriate forum to announce to a big group of staff that there are redundancies. There are ways that you could do that, but you just need to think about how those staff are going to be feeling having been given that announcement afterwards. For individual consultation meetings, then the remote video platforms work really well and shouldn't cause too many problems. think about who needs to be present at those meetings. So you may want to have some HR support in some meetings if, for example, the manager is running the meeting, so there's somebody there to provide support on process and take a note. The individual, depending on where you are in the process, may also want to be accompanied, and that's absolutely fine. You can adapt the process so that you can have a few people on that video call if necessary. Staff who are furloughed can take part in a consultation process, even though they can't carry out any work for the employer, so it's no problem to ask them to take part in a consultation process. You may, of course, particularly now, have some staff who are working remotely or are furloughed and some staff who are present in your workplace. So you need to think about how it's best going to work to reach all the groups of staff that you need to consult with. So can, for example, your remote working staff come into your workplace for an in-person meeting if you can socially distance appropriately, for example? Think about staff who may be shielding. So do you need to put particular arrangements in place for them? So absolutely, it's manageable, and we've helped lots of clients over the summer with running remote consultation meetings, but it does present some additional challenges which you need to just think through. So I'm going to hand back to Gareth to pick up alternative employment.
Thanks, Caitlin. So thinking about alternative employments, when you're looking at managing alternative employment, there are I suppose two issues. There is if there is some ability to redeploy somebody, whether that's done on a trial period, and there is a statutory trial period scheme which you can use, which is 4 weeks, in terms of whether people are well suited both from their own point of view and also from the employer's point of view in relation to that alternative employment, and whether that's then successful or whether it's still a redundancy situation at the end of the 4 weeks. There's also sometimes a challenge as to whether the alternative employment is what's known as suitable alternative employment, and that has a very specific definition in law. If you're saying to an employee, I'm offering you suitable alternative employment, then in those circumstances, you'd be saying if they don't take it, then you potentially don't want to pay them a redundancy payment, and essentially they are resigning at that point. And there are some very specific things you need to think about as to whether the employment is suitable for that person in relation to the skills and aptitude of that person, and whether you want them, that they're able to undertake that alternative role, and also the terms and conditions that apply to it. There's an objective basis, but the employer is saying, we think you can do this job and it's well suited to your skill set. There's also a subjective element to it, and an employee may be entitled on a subjective basis to turn down the offer of suitable alternative employment and still be entitled to receive redundancy payment. So, for example, if somebody says, well, yes, it's suitable, I can do the job, but it's not the way in which I saw my career developing, or I think it's a sideways move, or it's not appropriate in terms of the travel commitments for my family, for example, they would all be reasons that may be subjective to the individual, but may be valid in turning down suitable alternative employment. And you'd have to be sympathetic to those, and then in terms of whether you want to pay a redundancy payment or not. So it's great to talk about alternative employment in a wider context and look at whether someone can be redeployed in the organisation. And then it's slightly more tricky if you're then going to say, well, actually, we've found you an alternative job. There is no redundancy situation. It's suitable alternative, as to the conversations that might be managing around that.
I'm conscious we've got quite a few questions coming in, and I'm just thinking about timings. I think we're due to finish at 10 today. Is that right, Emma?
It is.
Yeah.
So I've got 3 or 4 questions that I've got to ask, but we've still got a little bit to do on legal risk and the final point on this slide. So
Sarah, I'm very happy to take the questions in relation to those. Rather, the legal risk were really a summary of how it can start to unravel with regards to challenges of a fair dismissal or a discrimination claim.
Okay.
It's probably if I just mention the CJRS point. It may well be for those who are using the scheme, you'll have seen that it's been updated by the 5th Treasury Direction in relation to the current scheme. And from the 1st of December, if someone's on furlough and you give them notice of redundancy, then you can't claim the furlough grant for the period of their notice period. you have to fund that yourself. So you need to be sure that you're properly claiming furlough payments, and obviously you can't claim furlough for redundancy payments either. So there's a bit of an incentive from the government in terms of the basis of how the furlough scheme is being used, and it can't be used to fund notice periods for redundancy going forward. Sarah, do you want to then go through the questions?
I'm gonna rattle through these. If there's a pool of people, they've got the same job title, but some have got higher skill requirement in terms of qualification, do they all need to be included within the same pool, or can you divide up? Or I suppose the other thing is that how you apply the selection criteria? What are your thoughts?
I suppose there's two things. I mean, ultimately, if should they all be in the pool to start with? It sounds like maybe they should, depending upon what you're trying to achieve through your restructuring or reorganization and redundancy. If you may be able to weight your selection criteria to reflect certain skills as being more important, or criteria that are particularly important, which may then reflect the higher skills qualification, or the level of skill qualification might in itself be part of the criteria that you want to use. Bear in mind whether there's any challenge from those who maybe are on a training path as to whether that's a fair thing in terms of how you get to that point. The other thing that comes up on those types of questions is obviously wanting to unsettle the fewest number of people. And some employers do take the view that they will apply the selection criteria to the pool, but then only inform those who are at risk, having done that they're at risk and go through redundancy, and the others are informed there's a redundancy situation, but told they're not currently at risk. If you've got a really small pool, it's quite difficult to manage that without allegations that you've predetermined the outcome and whether you've properly applied the criteria. But if you've got a pool of more than 2 or 3, then it may well be a way of managing it is to actually have done some of the homework first and then tell employees where you've got to and then consult from there. So you're only consulting with those at risk.
Thank you. We've sort of covered this next one a little bit, but I think it's around alternative employment and redundancy package. You talked about suitable alternative employment. In respect of trial period, if it doesn't work out, can an employee still have their redundancy pay?
Generally, yes. Yes.
Okay. I'm just going to move on to one here. A situation where you've got someone who's pregnant or on maternity leave during the redundancy process. What should employers consider in those cases?
So there are some maternity regulations that apply that if you are putting somebody who's on maternity leave at risk, you can do that. You can go through a redundancy process with them. But when you get to thinking about alternative employment, if you have vacancies or roles that are potentially suitable for that individual, then it's one of the small areas where there's some positive discrimination. You do have to offer that role to the maternity leaver first in preference to everybody else. And there's called Regulation 10. There's some particular requirements about thinking through the role and whether it's suitable. But essentially, if it is, you have to offer it to the person on maternity leave first in preparation for them coming back. There's some discussion of extending that role to anybody who essentially, when they inform their employer that they're pregnant, so they're about to go on leave, or they're planning adoption leave or shared parental leave, that they also get priority in a redundancy situation in terms of alternative employment. That's been out for consultation. I think it will come, but it hasn't yet been introduced. So at the moment, it's only those who are specifically on leave, but you do need to bear that in mind when you're managing alternative employment.
I think we're just after 10, so I'm conscious that people might want to drop off, and that's absolutely fine. But I'm hoping Gareth and Caitlin have just got a little bit of time to deal with the last few questions that we've got on the system. The first one is around the practicalities of those staff who are extremely clinically vulnerable and don't have the IT in place to be able to have a remote meeting. Can you do a face-to-face meeting? If you can do it in a socially distanced way, and that's supported by occupational health, or if you can't do it by a conference call, can you do it in writing as a sort of last resort?
Caitlin, do you want to think that through?
Yeah, I think with these cases, you'd absolutely need to do it on a case-by-case basis, and you'd need to talk to that individual about what they are comfortable with, and get them to agree to a meeting if they feel comfortable with that, and you feel that you can put those socially distanced, you know, you can do it in a socially distanced way, and they're comfortable with that, then I think you could go ahead. If they are not comfortable with that, I think you would need to find another way of doing it, and a phone call could be the way that you do that. It's not ideal, particularly if they have got a union rep they want to bring along, for example, but there will be ways that you could set up a conference call to do that, hopefully. I would think doing it in writing would be an absolute last resort, and I would be trying any other options rather than that if possible. What I think you wouldn't want to do is be forcing somebody to do something that they were uncomfortable with. I don't know if you've got anything else to add on that, Gareth.
No, obviously, I think it's hard, isn't it? If you can't see someone's reaction, it's as much about just seeing somebody and engaging with them as well as actually listening to what they have to say. So it's much harder if you can't meet that person. And so I would always try and find a way of being able to facilitate that. But absolutely can understand that if someone is extremely clinically vulnerable, that's going to be quite difficult at times. So you may need to take your time, and it may well be it's a bit of a slower process. And
sorry.
And maybe the only other thing is, whilst we talked about the right to be accompanied, which doesn't strictly apply in a redundancy, but good practice generally you will offer it to people to give them support. But maybe if they've got someone close to them who can help engage in the process, then that may be another way of just making it slightly easier to manage the process.
The final question is about where you want other team members to absorb the work of another and make a redundancy. So can you identify an individual for redundancy by passing on some of their work to others, so absorbing it within the rest of the team? But are you undermining your case? Because if you're having other team members absorb work, you're effectively saying that they aren't fully utilised, and should they therefore be in the pool themselves?
I think it's probably starting from the beginning as to the person whose roles are being absorbed by others. Are you saying you don't need that role anymore? So you've essentially got a pool of one, and you've got a discussion with that person as to why you don't need that, say, level of supervisor or manager, because you're flattening your structures, you're basically just establishing a role. Or are you saying everyone just has to do a bit more, in which case I think you are in a pooling situation, and you would have to broaden the conversation to the pool in order to then say how you're looking to redistribute the role, then there potentially who's at risk. So I think it would be starting with what are you trying to achieve and how are you positioning it, in terms of, are you removing a layer of management or a particular role because it's not a full-time role anymore, and then the other bits of that person does can then be picked up outside of that.
Thank you. Unless anyone's got any other questions they wanted to raise, that covers off all the questions and answers. So I think that just leaves us at the end of the session, and to say thank you to everybody that came along, and hopefully we'll catch up with you soon at another one of our events.